Good morning to all. I am Muthuselvi, Assistant Professor, Department of Commerce with Computer Applications, Dr. Drsnsrcas, College of Arts and Science, Coimbatore. Now I am going to discuss about the subject of commercial legislation and ethics. In that subject, first we discuss about the nature of contract. The nature of contract refers to the fundamental characteristics and essential elements that define the agreement between the parties. Understanding the nature of a contract is crucial in contract of law as it is lays the foundation for determining the rights and obligations of the parties involved. Here are key aspects of the nature of contract. Definition of first definition and formation of the contract. Definition: a contract is a legally binding agreement between two or more parties that involves an exchange of premises and the breach of which may be remedied through legal actions. Contracts are formed through an offer and acceptance. One party makes an offer and another party gives an offer, creating a mutual agreement. Next, volun- voluntariness. The parties involved in a contract must enter into a agreement willingly and without consideration. Mm, Agreements are generally not legally enforceable. Uh, Consciences. They must be a meeting of the mind, meaning that both parties must understand and agree on the terms of the contract. Next one, legal obligations. Enforceability. A valid contract creates legal obligations that the parties are bound to fulfill. Failure to meet these obligations may lead to legal consequences such as damages or specified performance. Next one is expressed and implied terms. These are the terms explicitly stated by the parties in the contract, either orally or in the written. Some terms are not explicitly stated but are info, inferred by the nature of contract or law. Next, certainty and possibility of performance. Certainty, the terms of the contract must be clear and defined, leaving no room for mm, ambiguity. Uncertain terms must render a certain unfor- unfortunable. Possibility of performance. The performance of the contract must be possible. If it becomes impossible due to unforeseen events, the contract will be discharged. Then consideration. Consideration is something of value exchanged between the parties should as money, goods and services and premises. Mutual, Mutuality. For a contract to be valid, there must be a mutual exchange of consideration between the parties. Next one, create legal relationship. In most commercial transactions, there is a perception that the parties insist to create a, a agreement may not be in case of social and domestic agreement. Legal formalities. Formal and informal contracts Some contracts require specific formalities such as being in writing or signed, or while other can be informal. Then capability contract. Legal capability to enter into a contract minors mainly incapable incapable individuals and those who understand the influence of drugs or alcohol may lack of capabilities. Then possibility of transformation and possibilities of terminations. Terminations contract may be terminated through performance, mutual agreement, breach, and other legal grounds specified in the contract or by law. Thank you.